Okay, the next case on the calendar is case number 24, People v. Assad, Cedeno.
Good morning, Your Honors. My name is Denise Powell, and I'm here representing Assad, Cedeno in this appeal.
Ms. Powell, would you like some rebuttal time?
Yes, Your Honor. 3 minutes, please.
Excellent. You have it.
Thank you. The question that this case presents is simply this. Can the people avoid a brutal violation by replacing a defendant's name with a blank space in a non-testifying co-defendant's statement that on its face inculpates the defendant? This question, I submit, was addressed and answered by the Supreme Court in Gray v. Maryland and by this Court in People v. Wheeler. In both of these cases, the courts held in no uncertain terms that this redaction method falls squarely within the Bruton rule. That is, it must be precluded. The Gray Court explained why this is so. In Gray,
Ms. Powell, is there any way that this statement could have been redacted so that it would be a proper statement to put before the jury? In other words, not blanks, but maybe somebody writing in something other than what the person wrote in, mail, or leaving the clothing description blank. Is there any way that this statement could have been?
This statement could not have been redacted with a blank, for sure. If you're asking me if there was an alternative method,
yes,
perhaps, but that's not this case. In this case, what the people did was inserted blanks where Villanueva described the clothing worn by my client, and it remained blank and was submitted to the jury for its review.
So if Detective Mosier, I think, had just read it with the blanks, and the statement itself hadn't been admitted into evidence, and there had been a proper limiting instruction that the court gave, then would we be in the same situation?
Had the jury not asked to see the statement?
Right. In other words, if he just read it, which other courts have done, and you don't submit the evidence in and of itself, and any redaction takes place, is invisible to the jury and doesn't fall under any of the Bruton-Richardson-Gray problems.
I think that's, Your Honor, is correct. I think that had it been read in a way where the sentences made grammatical sense, where it wouldn't have alerted the jury that something had been altered on the face of the document, then I think perhaps it might have survived a Bruton challenge.
Isn't what matters what's altered, not just that something has been altered? It's the point of what that alteration is and the impact it may have on the jury's fact-finding determination.
For sure. Because if it's altered, I mean, I'm not sure that there would be any basis to alter anything other than the identification of a co-defendant or a defendant. But yes, I think the alteration has to go to the name or the identity of the accused.
Would he have to redacted the reference to the gangs?
He should have. Absolutely, because that obviously narrows the field.
Connects
narrows the field and connects my client to the incident. So in Gray, the Supreme Court made clear that when the redaction is apparent on the face of the non-testifying co-defendant's statement, those kinds of redactions fall into the Bruton scope. And the reason is simply clear, because a juror who sees a non-testifying co-defendant's statement will see the blank on its face. It'll jump out. They'll focus on it and ask the very simple question, who are they trying to hide? And the obvious answer, they'll look to the defense table and they will just fill in the obvious blanks with the defendant's name.
Does it matter when it's a situation where you have several potential suspects, even if you're talking about your client and one defendant? Mm-hmm. Does it make a difference? When there may be many to choose from, let me put it that way.
Well, that's, I think, what the people are trying to suggest.
Well, yes,
that whether or not that this case is removed from Bruton and Gray because there were, let's say, more participants than defendants on trial or number of redactions on the face of the document. And I submit that is not, that would not remove it from the Bruton scope of the Bruton's preclusionary rule for this simple reason. Again, the jury will look at the document, They'll see the defendants at the defense table, and they will fill it in with the obvious answers, the defendant sitting next to the non-testifying co-defendant. This argument that the people raised on appeal and raised below was actually raised in Gray. The factual situation was virtually identical to the factual situation here. There were more participants in the Gray case than than actually being tried, and also more than the number of redactions that were on the face of the redacted statement. In Gray, there were 6 participants. There were 2 defendants, though, on trial and 2 redacted names. And that did not stop the Supreme Court from holding that type of redaction, even though there was no one-to-one correspondence between the number of participants and the number of redactions. It still fell within the Bruton scope. And in fact, and I should note that the people actually raised that argument in Gray, and the Supreme Court rejected it.
How was Wacone's statement about the defendant's nickname, how is that facially incriminating?
Huacon? Huacon. Well, she was she identified herself as my client's girlfriend, and she said in an out-of-court statement that my client's nickname was Bambino.
But so how does that statement on its face, how does that incriminate without tying it into a whole bunch of other testimony and evidence?
Well, Huacon's statement is actually coming in under a different type of error. We're not
you're not claiming that's a Bruton error?
It's a hearsay problem and a confrontation problem, because in Huacon...
Based on the police officer's testimony or the detective's testimony, or based on her statement?
The detective testified about her out-of-court statement, but she was not a co-defendant, so theoretically, technically, it's really not a Bruton problem. It's really a pure hearsay confrontation problem. And it is incredibly incriminating because, in fact, there were witnesses that claimed that they knew my client by his gang king, his Latin king gang nickname, which was Bambino. So that testimony not only tied him to the Latin King gang, but also corroborated the people's witnesses.
I thought they objected there, though, and the court sustained the objection on Bambino.
Actually, counsel repeatedly objected to that testimony coming in. Mm-hmm. The court overruled the objection, and then, of course, it came out. And then subsequently, counsel said, there's no way that error can be cured. I'm moving for a mistrial.
I see.
And that's,
okay. Can I just take a step back a second to the issue I was asking you about before, which is the failure to give a limiting instruction. Did you raise that issue? Did you argue that in your briefs?
I complain about that. That obviously
I saw that, but I don't remember it as a separate heading. And the reason I asked is because I didn't see any objection to it, and I thought that the people said that issue wasn't preserved. And logically, it seems to me that that's, for you to be successful, that's where you have to end up. That's why I'm asking it.
Counsel asked for an instruction at the charge conference, I believe. But the instruction that was given was defective, in my view, but there was no subsequent objection to it.
I see. So he asked for it but didn't object to the charge it was given.
As given.
Yes.
Correct.
Thank you.
But just to emphasize that point, counsel moved in limine on Bruton grounds. It was
correct, yeah.
it was the people's obligation to correctly redact the statement. And this court has held in People v. Smalls that a motion to sever preserves the issue.
You understand what I'm saying, though, is that there's a difference between redacting the statement and the statement going into evidence and then not
the actual charge. Correct.
Yes.
I understand.
Counsel, can we move to the identification procedure at the precinct house for a moment?
Yes. I think that that area of the law is settled, well established. A precinct show-up is inherently suggestive, and it's unconstitutional unless supported by exigent circumstances.
Did you argue that, though? I thought the argument at trial was that it was tainted by the identification at the scene. I don't recall that this argument that you're now raising was raised at all at the trial level.
Counsel complained about the joint, because not only was it a precinct show-up, they actually showed or displayed my client with, I believe it was 4 other suspects who were arrested at the scene. And yes, counsel complained that that joint identification was unduly suggestive. And the court ruled, and the people also argued that that was not, that was a completely proper procedure, that it was confirmatory, even though there was no evidence to support that. There was no evidence that, in fact, the identification witness had a sufficient level of familiarity with my client so that that could be a confirmatory ID. And the court, in the end, accepted that rationale.
Is there some other rationale for having the quote-unquote confirmatory show up at the precinct? There were a number of people who identified several individuals at the scene of this essential melee. And then there were, I guess, one of the reasons that the police wanted to have this show up at the precinct or lineup was to cut people loose who really weren't involved, or, you know, confirm whether these were the people who were actually identified at the scene. Is that a legitimate purpose for the show up?
For a precinct show-up,
Would that be considered a confirmation?
they were arrested already. If, and this, as this court has held, any time that you display a suspect, a defendant, whether or not it's in person or a photograph, that is subject to, it must pass constitutional muster, that it cannot violate the defendant's due process right. It doesn't matter what the cop, what his subjective intent was. If he needed to, you know, confirm that he got the right people or whatever, the point is that it's still nonetheless a pretrial identification procedure that must be done in a way that does not violate the defendant's due process
So would
rights.
the facts of a chaotic melee with multiple people under arrest and multiple witnesses in the precinct house, would that rise to the level of exigent circumstances?
Of exigent circumstances? Absolutely not. At that, the record clearly shows that after my client and others were arrested at the scene, at a show-up that was also challenged, I might add, and the people in their brief admit that that show-up at the scene might very well have produced unreliable identifications. So logic tells us that they certainly should have conducted unsuggestive, proper lineups at the precinct.
So what would that have looked like, considering these particular circumstances? What would not have violated your client's constitutional rights?
Well, I don't want you to show my client in a group, in a precinct, with other suspects, and also where the witnesses are allowed to chat with one another, not only before the show-up, but also after the show-up.
And during?
And during. So they were actually talking to one another after they already identified.
Someone would go in, do an ID, come back, come to the group, and as far as you know, they were chatting about what just happened. The next person goes in, comes back, same thing.
That's exactly what happened.
It seems like it's the minimization of how long they want to keep the suspects lined up, and this court has addressed that in Rodriguez.
The court has addressed that question and has rejected that as a basis to do a precinct show-up.
It's not exactly the same situation, though, as the judge said. But that isolated by itself, you're right about
That's right. It's not enough.
Thank you,
and
Ms.
in 4 hours.
Good afternoon. May it please the Court, my name is Nancy Talcott from the Office of Richard A. Brown, the District Attorney of Queens County, on behalf of the respondent. The redacted statement did not explicitly or implicitly identify the defendant. It contained no names, no nicknames, no identifying feature or clothing description linked to the defendant. Even the unredacted statement could only be linked, if at all, through a generic clothing description.
What do you think of Ms. Powell's argument, though, that when you leave something out and the only person that could possibly have been left out is the person sitting over there at the defense table, the jury can reach that kind of conclusion by themselves?
It was not at all clear who was left out. That's the point. There actually was no Bruton issue here. The defendant reading of Gray places form over substance.
Wait a minute. You said that, but she said the opposite. I was wondering if you could clarify that. In other words, she's saying here's one person sitting there being tried, and there's blanks in this thing, and a logical jury is going to say, well, obviously the blanks apply to this defendant. Does that make sense?
No, not under the circumstances of this case, where you had 100 people at the platform, at least 15 suspects, 8 were brought to the precinct. No, it's not clear at all to whom he referred.
I'm looking at it a little more narrowly. I'm thinking you're in a courtroom and you've got what, defendant on trial. Somebody says, I want to redact this thing so that the jury, doesn't reach the wrong conclusions. And they do. And if it's read, as Judge Fahey suggested, and they never see the blanks, then things seem to be okay. But when they see the document and there's blanks, Ms. Powell's point is that they're going to, whether they're right or wrong, they're going to assume that the blanks are the defendant.
Well, they weren't under the circumstances of this case because it was clear from all of the evidence presented at trial that more than these defendants sitting at the table were involved.
But wouldn't I mean, if I was a juror, I'd say, well, if it was somebody else, they'd leave the name in.
No, absolutely not. First of all, it's clear from the statements as redacted, it didn't actually name anyone. It named some undefined Latin king. So that wouldn't be clear to the jury at all who it named.
You're kind of missing my point, but go ahead. That's all right.
Sorry?
That's okay.
I think the point is, why are the people going to go through what is clearly an expensive enterprise if they don't think they got the right Latin king? And isn't that what's obvious then from this statement that's redacted as such?
No, not when it's clear that there were so many other participants, potential suspects, and also defendants not sitting at that table who were also
What
armed.
about the connection to Bambino?
Oh, the Detective Wachowski's?
Wachowski, yeah.
Well, again, that's not a Bruton issue. It was inadmissible hearsay. The court sustained the objection. Defense counsel declined a curative instruction. And as the appellate division found, there was no significant probability that the error contributed to the conviction. Hierro said he knew the defendant as Bambino. Figueroa said he knew the defendant as Bambino. And quite frankly, defense counsel referred to the defendant as Bambino in his summation. When he was talking about them all getting together, let's pin it on Bambino. So, and in light of the overwhelming evidence of guilt, where you had those 3 witnesses, 2 of whom knew him and identified him as such, there's no possibility that that error, which was inadvertent.
Counsel, backing up a little bit, does the element of the crime of gang assault that you have to be aided by 2 or more other persons actually present, does that make the redactions in this case irrelevant?
I think Jass addressed that, the Second Circuit case, where they said sometimes due to the nature of the statement itself, it can't be redacted to omit reference to the third person, which the Second Circuit has stated is a preference. You can't do that here grammatically, and also given the nature of the charges. In Jass, you had conspiracy. Here you have gang assault, where you do necessarily need a certain amount of people. So Jass did acknowledge that that was, in fact, a factor to consider when determining whether the redaction has to refer to somebody. And again, in Jass, it's not a numbers game. In Gray, you had more than people sitting at the table, and in Jass, you just had one. One defendant, one redacted person's name.
Counsel, even though there were more people involved, there were only 3 people sitting at the defense table. And I go back a little bit to Judge Piggott's question. Why would the people go through the trouble of doing any redactions if none of those things redacted referred to the individual sitting at trial, regardless of whether there were other people involved in the melee?
Well, under the circumstance of this case, it would have been linked to the defendant, and that would have clearly been a problem. So you had to in this case, because the indication was that the defendant wore red shorts and that Caceres had worn a black tank top. Now, had it described Huacan, or indicated her clothing or anything, it still would have been redacted. Because you don't want any indication of who it referred to. The statement was admitted against Villanueva. It was incriminating as to him. He put himself at the scene. He put himself in the particular car.
Did the court ever instruct that it was limited to that?
No. Any
And-
claim
and so-
regarding the court's charge, which is, to Judge Fahey's point, is unpreserved and in fact waived. The court specifically said, after the charge was given, any additions. The defendant, this defendant in particular, said, oh, could you say something about the redactions? Judge said, you want me to just tell them not to consider the redactions? Yeah, pretty much. The court then made clear to the jury there have been some things redacted, pay no mind to them, it's a legal issue, they have no bearing.
Yeah, but let me ask this. If we apply Gray, the way I understand Gray is that any visible redaction is prohibited as a class. That's kind of the way I read that. So if, I could be wrong, wouldn't be the first time. But assuming that's correct, if any visible redaction to Gray, this court hasn't applied Gray yet, I don't believe. So if we applied it to this circumstance, preservation wouldn't really matter then, would it, on the limited instruction?
Well, I think there was a strategic reason not to request the classic Bruton instruction, for lack of a better word.
That's fine, you can get to that.
Okay.
But if we applied the Gray formula, would that set aside the question of no limiting instruction?
No, because I think that reading of Gray is too narrow. Again, I think it's form over substance. Gray does not stand for the proposition that, oh, I have a statement with a blank, Bruton problem, end of story. You have to look at what the blank and the statement and everything says, what that communicates to the jury.
Well, see, it seems in terms of trying the case, it's relatively simple. You don't submit it, you don't show it's visibly redacted, which means you don't hand it in to them. So they get the statement that's unredacted. Redacted means they shouldn't know about it. They don't know about it. It's straightforward. You got Witkowski or whoever the other guy was, Moser, on the stand.
Right.
They read the statement. That's the end of the problem. It doesn't seem to be, from a people's point of view, I don't see how it creates a problem. And it's simple enough. If the jurors want the statement, they want the statement, it's simply read back to them by the court reporter. These don't seem to be insurmountable problems to me.
No, nor did the defense ask for that. And again, there could be strategic reasons.
The question isn't that, though. The question is whether or not if we applied Gray in the Gray formula, which we haven't done before, then there would be no requirement to preserve it because the visible redaction wasn't an error. In other words, my reading of Gray that I gave you hadn't been an error at that time. We'd be saying it's error now.
Well, I think it's more than just visible error. Again, Gray doesn't otherwise Gray would mandate that you have to retype everything. And which Judge Scalia noted in the dissent, there is no such mandate. In Richardson, they actually did, but all the parties agreed. The defendants never said, let's retype it. And again, there could be strategic reasons for that. Villanueva didn't write his statement. Maybe they want to say, like, see, the cop wrote this. There's corrections on these statements, initialed. You know, there could be defense reasons for not wanting it to be retyped. They certainly could have asked. That's another possibility. Or they could have said, we don't want the physical document going in. We don't want them. In fact, it's clear the defendant didn't have a problem with it because that's the specific charge he asked for in this particular case.
The way I understood it was is the defense argument was that they objected in conference, but not after the charge was given.
No, they didn't ask for the classic Bruton, like I said, for lack of a better word. And again, given this case, where it did not in any way identify the defendant, it didn't link him to the defendant, the defense may well have had a strategic reason not to. All of a sudden, you have the judge saying, oh, you can't consider this against him. They might be saying, well, why would we have? Whereas here, there was no indication this was the defendant or anyone in particular other than someone identified as a Latin king. And here, given the large number of people that would have fit into that class, it makes it even less likely.
Where's the line in the sand about what the statement as redacted indicates? I mean, is it just you've removed anything that shows that might connect them because of a physical description, or as you said, the red shorts or something like that? How far can you go?
I think Jazz sets
But inferences can be drawn that perhaps cross the line.
I think Jazz sets forth a good standard. Exhibit a preference to remove all reference to the people. And again, we discussed you can't always do that grammatically or given the nature of the charges. Then you posit two questions. Whether the redacted confession indicated to the jury that the original statement contained actual names. That's where you had Gray. problem in Gray was it substituted a name with an obvious indication that it occurred to protect somebody's identity. And whether the redacted confession, even if the first item introduced at trial, would immediately inculpate the defendant in the charged crime. You give this jury this redacted statement in a vacuum, they have absolutely no idea who Villanueva is talking about. There's absolutely no connection whatsoever to the defendant. Again, supporting a theory that they may not have wanted the classic
Do you
brutal
want us
charge.
to adopt that particular reading?
I think it balances the protections Bruton seeks for the defendant against the interest in having joint trials in cases like this that the state has, and I think it strikes a fair balance. There are certainly other options that the defense can choose to request that the physical statement not go in at all, as Judge Fahey indicated, or to have the statement itself retyped, as all the parties agreed to in Richardson. There's no mandate right now that that occur. And in fact, there may be reasons why they may not want it to occur. Finally, in this regard, error, if any, in the admission of the statement was harmless. There are two questions: the quantum and nature of the evidence against the defendant if the error is excised. Here you have 3 witnesses identified him. 2 of them knew him. They knew him by name. One had been a former gang member. Another one saw him at school a few times a week regularly.
Well,
2.
they had some credibility problems. You would agree with
All
that?
before the jury, absolutely. The second question in the harmless error in this situation is the causal effect the error may have had on the jury. The jury's verdict makes clear this statement had no effect on them whatsoever. If it had affected the jury, the defendant undoubtedly would have been convicted of manslaughter, at the least, if not murder. If the jury had given it any credence whatsoever, Villanueva would have been acquitted of everything, when in fact he wasn't.
On the other hand, they specifically asked to see it, so it was obviously something that they paid some attention to.
Well, they asked to see all the exhibits, actually, I think, and the statements as well. And, you know, that's where we can't delve into the deliberative process. We really don't know if one person wanted to see it. We can tell from the verdict that they didn't buy it. Why they asked for it, we don't know. And that's just going to be pure speculation, whereas there's no speculation with what the verdict was.
Can you address the
Could you
lineup?
comment?
Can you address the lineup issue?
Yeah, that's what I was going to, the confirmation.
Just going to swap notes.
Is there another way you could have done this confirmation?
Well, it didn't have to be done at all. So as a practical matter, they had the identifications. The only thing that would have resulted was that somebody possibly implicated at the scene would have been exonerated. They didn't have
But
to.
they did go forward, so now you're
Right.
stuck with it.
So the question before the court, this is a mixed question of law and facts. So the question before this court now is whether there's record support for the lower court's hearing, the lower court's finding, which the appellate division left undisturbed, that under the circumstances, whether these show-ups were reasonable and not unduly suggestive.
Well, how are they not unduly suggestive, sorry for the double negative, if you have those witnesses or potential witnesses who are identifying, going back and forth and having a conversation?
Is that accurate, that description of the process?
They were together. And actually, Detective Lopez said, yeah, we kept them together under the circumstances because the identifications were done.
But were they allowed to talk during the identification process, come in, come out
Well,
of the room?
one came in, I think they went back to the same room. But again, if that was going to unduly impact them, then why is Hernandez the only one who puts a box cutter in his hand? Everybody doesn't put a box cutter in the defendant's
I'm
hand.
sorry, I'm a little unclear about your response to Judge Garcia. Are you saying
but yes,
they did go back and
they did
forth
They didn't
between
go
the
back and
IDs?
forth. One went,
Right.
then he came back, another one went, then he came back, yeah.
Right.
So, like, I don't
Those were
think
for
they did.
identifications. One may have added something about a box cutter or not a box cutter, but what they were saying is this is the person or not the person that I saw.
Right.
Right.
He was just consolidating the information gathered at the scene. And just as an
Were they in that
aside,
room together without any police? They by themselves?
I think an officer was outside.
waiting?
And actually, I think at one point one of the officers said he was chatting with the kids. And that's clear from when Wakan walks by and they start identifying her, and they take a couple separately. And again, that's where you hadn't had that identification. They do remove them and discuss with them separately. So they were cognizant of the fact that, you know, okay, we have to keep this separate because she hasn't been identified yet. So, but
Counsel, why didn't the people proceed with an independent source hearing?
there was no need to, because you need an independent source hearing when you find that the show-ups are suggestive. So the court found that they weren't suggestive, so there was no need for an independent source hearing. And under the circumstances of the case, just the people don't concede that the initial IDs were questionable, of questionable reliability or inherently unreliable. Defendant doesn't even argue that now. What Detective Lopez said, what our argument is, given the potential for miscommunication, under the unique circumstances, where you had 100 people, 30 to 40 cops, multiple witnesses, making different identifications to different officers, in an area that had become a crime scene. A victim was laying dead, and they're collecting evidence, which included weapons.
Does that make it exigent?
Well, exigency isn't the only factor. Riley says,
So, but would you agree that it doesn't make it an exigent circumstance?
well, if it has to be couched in terms of exigency, although I would say the real question before this Court is reasonableness, the exigency that existed at the scene was the same exigency that existed at the precinct, which is to let anyone who really wasn't involved go. But the
Wouldn't
question...
that then be the case in every time that there was a precinct show-up?
No, it depends on the circumstances. Again, here you have a continuous, although it's 3 hours, there's no bright line regarding the time, you have a continuous series of events. You know, Duvon talks about the unbroken chain of events. This chain is unbroken. It's just a little longer.
Why isn't that just inconvenience as opposed to exigency?
Well, again, I don't think the question before the Court is
But what's at risk?
exigency.
What's at risk other than someone, I'm not saying it's pleasant or we should violate anyone's rights, don't get me wrong, but what's at risk? What's the exigency? What's the danger?
No,
What are
well,
you concerned about?
I'm not claiming that the primary motive here was exigency. The existence of exigent circumstances can be a factor warranting the employment of a show-up identification. Exigency is by no means the requirement for a show-up to be admissible. And again, the question before the Court on this mixed question of law and fact is whether under the circumstances there's record support for the hearing court's finding.
Thank you.
Just a couple of things, Your Honors. First of all, there were 4 hours between the time of the at-the-scene show-ups and the time of the precinct show-ups. There was plenty of time to conduct proper show-ups. And it's settled that for a precinct show-up to be admissible, to be constitutional, exigency must be shown. And none was shown, and none was claimed in this case. The other thing is that people
Counsel,
continue.
what about the question of whether there's record support for the lower court's decision? This is a mixed question of law and fact.
There is no record support. In fact, the people made no claim that they could not conduct proper lineups. This is a claim that they're coming up with on appeal for the first time. So, in fact, that issue is not preserved, and it cannot be a basis upon which this Court can affirm. And as to the hundreds of people at the subway station, in fact, the people in their opening statement narrowed who was involved. The prosecutor said that there were 4 or 5 people who ran out of the second car, and 3 of them, Caceres, Villanueva, and my client Assad Cedeno, were the ones who had the knives. So when they looked at Villanueva's statement where he claimed to identify those who were armed with knives, who was he talking about? Cedeno and Caceres, not the hundreds of people who were.
Well, just to clarify then, is your point that by the time they get to, we're still talking about the lineup, the time they get to the lineup, the police already, that's what they're doing, or at least already, they're not talking about hundreds of people. They're really only
Actually, I was
talking
referring
about, am I misunderstanding you?
I was actually trying to address the people's argument that, that the jurors would have no clue as to whom Villanueva's statement referred to.
I'm sorry, you're on the brute. My apologies.
For all the reasons that I argued in my brief, please, I ask the Court to reverse.